My name is Scott Miller. I'm the William M. Scholl Chair in International Business. I'd like to welcome you to this event on government-sponsored patent pools, addressing innovation mercantilism. For those of you in the room, I want to let you know there is an online audience, and I'd like to welcome that online audience. The event, if you're interested in a replay, will be available at CSIS.org at the events page as soon as we can technically manage such a feat. But we thank you for those of you online who are joining us. Also, you can follow us on Twitter at #CSISLive. Today's event is the first in a series on innovation in the trading system. Intellectual property rights, particularly patents, are often the most commercially important asset for a globally engaged firm. Evidence of this can be seen in the information and communication technology industry. This is an industry that is characterized by highly contested markets and short product life cycles in which innovation tends to drive consumer choice. You've all read about, of course, the smartphone wars. The smartphone wars basically is the way the media has characterized patent litigation by many of the key players in this industry in multiple jurisdictions. It can lead to odd events and incidents like firms spending more on legal fees than on actual research. So it's an odd set of circumstances, but it does underscore the value of ideas and know-how in today's global economy. Likewise, there's a long tradition of government intervention in what are contemplated as key sectors, whether it's protectionist trade measures or industrial policy or the behavior of industries that are outright owned or controlled by the government itself. While these kinds of interventions are very well known when you focus on areas like industrial production, in today's world of global value chains, the notion of government intervention in the key elements of production are changing. In fact, Richard Baldwin, one of the key analysts of the rise of global value chains, has basically characterized the core driving force of value chains as not capital, but know-how. It is that knowledge and ideas and intellectual content that is so important in making things work in global value chains. This has given rise to various forms of innovation mercantilism, that is, government promoting regulation which discriminates against foreign ideas, foreign intellectual property, to the benefit of locals. Famous example of this, of course, was from 2006, the China's indigenous innovation policy, but it can take many, many forms. Today's event is going to discuss a very specific form of this kind of activity, where governments use intellectual property to engage in a discriminatory policy to help national champions at the expense of foreign competition. Let me talk for a few minutes, for those of you like me who aren't patent lawyers and had to figure this out. What exactly is a government-sponsored patent pool? And how do these activities, how does this structure differ from other entities where there is government support, or more importantly, other general government actions such as contributions to research and development activities at universities or elsewhere in the economy? A way to think about this is, up to now, there have been basically four main classes of patent owners. The first and most familiar would be operating companies, whether it's a General Motors or whatever the firm might be. Think of a firm with a research and development organization which creates innovations, and those inventions are then patented in order to advance business goals and to achieve a competitive advantage in the marketplace. We're quite familiar with that. A second class of patent holders would be inventors which file for patents but do not practice them, whether it's individuals or universities or corporate entities who operate basically to create the innovation and then license their patents instead of manufacturing them themselves, often called a non-practicing entity. A third group would be patent pools, and patent pools are made up of inventors in the first two classes. And the pool itself usually facilitates licensing arrangements between the parties or among the parties and protects the members from outside litigation. Now, patent pools are quite a common feature in many very competitive industries where you have lots of inventors working in a similar space. So the high-tech industries use a lot of patent pools, and there is nothing either wrong or inherently destructive about a patent pool or inherently uncompetitive. In fact, many patent pools can be quite beneficial for both innovation and for consumers. A good example of this would be NV Philips and Sony and other electronic firms which formed a patent pool to govern the development and standards for the digital video disc, the DVD. Those of you who have gray hair like I do will remember in the previous iteration of the VHS versus Betamax controversy, where when you went to Blockbuster Video, they had the wrong tape in stock. Well, the industry worked well together, Philips and Sony being the leaders, worked well together in the form of a patent pool to develop common standards and common applications, so everybody's DVR or DVD works in everybody else's machine. So it does have some benefits. So that's the third category, patent pools. The fourth are commonly known as patent assertion companies. Now these are companies which may or may not have inventors on staff, probably don't, but they're basically in the business of buying and enforcing patents as an asset. Now they often are disparaged. We sometimes call these trolls or whatever it might be. But the fact of the matter is patents are an asset like any other asset, and to have management firms trying to maximize the value of assets is totally unsurprising and frankly welcome in a market economy. So those are the four basic actors in the patent system, the classes. The new actor here is when the government itself forms the patent pool. Same structure as a patent pool I described, like the Sony Philips DVD pool, but it has a different rationale. The stated reason is often to further the domestic innovation, as well as to protect domestic firms from litigation by foreign enterprises. A couple examples of this might be the government of Korea formed a firm called Intellectual Discovery. Intellectual Discovery has about 3,800 patents, about $250 million under management, so it's relatively sizable. Likewise, the government of Japan has a firm called Innovation Network, government-sponsored, which is a little bit smaller than Intellectual Discovery at the moment, but has a goal of over 5,000 patents. France Brevet is another common example, roughly 300 or 100 million euros under management. Half the funding came from the French government itself, half from a government-controlled financial firm. In the case of France Brevet, they have an explicit goal of maximizing revenues to France, and have been frequently utilizing foreign courts, including US courts, on behalf of French patents, in some cases regardless of the initial claims, the patent claims legitimacy. In essence, what you have is a scope for IP litigation as a new form of trade defense, similar to anti-dumping or countervailing duty. Today's conference essentially poses the question, what is the role for trade policy in this new form of protectionism or innovation mercantilism? There are clearly long-time disciplines in the GATT on subsidies and on anti-dumping and countervailing duties. So the real question for the audience and for the panel today, who will join me in a second, is to talk about how should trade policy professionals view this space, what are the issues, and do some of the disciplines that have been applied in the past conceptually apply to this new space. We'll discuss the practice itself of innovation mercantilism. So we'll discuss the trajectory. Where is this going? Who's involved? How successful are the entities? And usually the important trade policy question is, if these are bad practices, will they spread? Spoiler alert, the answer is usually yes. But we'll talk about that in detail. And third, we'll talk about how trade negotiations might begin to address the issue and apply some guardrails to this practice. I'm pleased to be joined this morning by an expert panel. We should have a terrific discussion. If I could ask the panelists to join me on the platform now, we'll get started.
Where do you want us?
You're good right there.
Right here?
Yeah. Malcolm and Tim. Hey, Mark. Welcome. Good to see you. You can sit next to Sean. Mark, thanks for joining us. Good to see you. the magic lavalier mics will have a comfy chair discussion today, which is great. In any case, let me welcome the panel. Immediately to my left, to your right, is Marc Busch, Professor of International Business Diplomacy at the School of Foreign Service of Georgetown University. Marc will start us off with sort of a big picture discussion of the issue. Next to Marc is Tim Traynor. Tim is the President of Global Intellectual Property Strategy Center and a career practitioner in the issue of intellectual property enforcement. And we'll have various views on this subject. You have copies of their biographies, so I won't elaborate further than that now. Next, we'll hear from Sean Heather. Sean is Vice President of the U.S. Chamber of Commerce Center for Global Regulatory Cooperation and one of Washington's experts on the issue of disciplines on state-owned enterprises in both the Trans-Pacific Partnership and potentially in the Transatlantic Trade and Investment Partnership. Finally, we'll hear from Malcolm Lee. Malcolm is a non-resident senior fellow at the Brookings Institution, but has a long experience in this space, first at Microsoft Corporation, and then also as an officer of the U.S. government. So each will bring a very different perspective. We look forward to hearing from the panelists and then engaging with you on your questions. So, Marc.
The sovereign patent fund strikes me as something that's going to raise a whole bunch of issues that sound very old-fashioned. Mm-hmm. On the one hand, I could imagine a very benign spin on this, and I could imagine offering the patent fund as being the equivalent of a large incubator or accelerator. And in that context, there is a lot to like about the idea of doing what the private sector has also done on its own, which is to pool its patents and to do something unique that confers competitive advantage on domestic firms. But therein lies the rub. Why sovereign? Why is this about domestic? As soon as we start thinking about a patent fund that is going to emphasize domestic in particular, the questions that pop up are procurement, subsidy, local content, and of course the state-owned enterprise issue. And on all four dimensions, there's something to worry about in a sovereign patent fund. On procurement, the question is how much of a role does the government actually play in the effort to stimulate and purposefully accelerate the bringing to market of ideas? And the procurement issue is really complicated today, especially in the wake of the loss by Canada in the feed-in tariff, because we have new limits on what procurement actually means under WTO rules, whether the government is the sole user of the good or service, or whether it could be the distributor of the good or service. And I worry about that on the procurement side, especially at a time when we are coaxing both China and Russia to join the government procurement agreement of the WTO. I worry about what kind of message we will send in terms of how the sovereign patent fund ultimately betters the chances of success of commercialization at home. The way to do that, presumably, is in a way that kind of implicates procurement in our worst case scenario. Mm-hmm. On subsidy, on the one hand, it could be taken as encouraging that it's conceivable that the sovereign patent fund does not run afoul of specificity, in as much as if you offer access to the patent generically, generic is perhaps not the right word in the case of pharma. If you offer equitable access across industries to the patents, I could imagine the argument being made that it doesn't run afoul of specificity and therefore doesn't put us in the league of something that looks like an Airbus subsidy. It's not specific to a firm or industry. My fear, though, is that in the race to do this kind of techno-nationalism part 2, we will limit access to the patent to domestic, in which case we have the local content issue. And local content I see playing out in several respects. One is with respect to the determination of the subsidy itself. We know that the prohibited subsidies under the Subsidies and Countervailing Measures Agreement, Article 3, says no export contingent subsidy and no subsidy contingent on local content. I worry about that here. But I also worry about the generic flavor of GATT 3.5, which tells us, again, no local content. And if I was to imagine something like a NASA patent fund coming together for the express purpose of only furthering US interests, I would worry greatly on both dimensions. And with respect to the loss by Canada in feed-in tariff, I worry that we're going to really be in the realm of the upland cotton subsidies, and we're going to find that there's a lot of pushback on the part of foreign jurisdictions that this not work the way that it might be planned, which is to optimize success. Finally, there's the SOE angle. Because as soon as you say something like sovereign wealth fund, sovereign patent fund, the first thing that comes to mind is subsidy by a state which is not arm's length from the user. And in that context, the United States has been at great pains to purge SOEs from the trading landscape. The US has great demands in this regard under a whole bunch of our bilaterals, and will continue to seek certain of these concessions under all future bilaterals. This is a new angle. This is an angle where the government may actually play more of a role because of the difficulty in harnessing ideas and in protecting ideas. So on all four dimensions, I have concerns. And what I hope we don't end up arguing is that the idea of a sovereign patent fund is a bad equilibrium for a bad world. Because I think these days we're excusing a lot of bad policies in that context. And I appreciate the dynamic, but it would be a shame if the best that we could offer for something that sounds like a sovereign patent fund was that it's a bad equilibrium for a bad world. I get that we might want to match, much as we do trade deals in the sense of competitive liberalization, but I fear where this is going to take us, and that the deeper we go down that hole, the more that this is going to run afoul of those four measures under trade rules.
Thank you. Tim.
Thank you, Scott. Thank you very much. Scott had posed just a general idea about what can we achieve in international intellectual property enforcement with regard to these funds. And I was thinking, I'm not so sure about the achieve part at this particular point in time, but I also thought about generically when you look at the basic rules under the WTO on intellectual property enforcement, patents are not something that are subject usually to criminal enforcement or even at the border like trademarks and copyrights. So in reality, when we talk about the enforcement here and about the state stepping into the shoes of the patent owner and then perhaps initiating lawsuits, we're usually thinking about it in terms of civil litigation. And Scott mentioned about the situation in the US where the French fund comes in and initiates litigation. But now the issue is where we have countries that have, for whatever reason, chosen to extend liability into the criminal area, or even to give authorities the ability to stop shipments coming into their country due to suspicion of patent infringement. I think it does expand, in that sense, the possibility of the state engaging in some interesting activities here. Because now, for example, in China, you do have criminal liability for patent infringement. You have customs rules, regulations that say Chinese customs can stop the importation of goods that are suspected of patent infringement, but China is not the only one. Interestingly, there are a number of countries that you wouldn't think of being more aggressive in these areas than the United States. We don't have criminal penalties for patent infringement, but a number of countries do. If you look at the most recent European Union regulations on border measures, it extends to patents. It extends to designs and other areas that we don't actually give customs the authority to go in and act. So it's interesting to me from an enforcement perspective that the challenge for patent owners will be to actually look country by country at the enforcement structure legally in these various countries as to just how active perhaps the government can be. And I think it's also interesting to note that one of the issues here is the government both as perhaps the regulator and then the patent owner or the entity that can initiate enforcement actions. Here you've got the government, if you will, in the broadest sense, potentially being the prosecutor, the owner, the police investigating and collecting evidence, as well as stopping things at the border. So you've got basically various arms or parts of the government engaged in all of this. And I think that as a U.S. patent owner, somebody that may potentially be subject to these kinds of enforcement actions, it really is a bigger question of what does that IP enforcement landscape look like in various countries where you want to do business. I used to look at it from a much more simplistic questionnaire that you just look at the basics, and given these developments that we've had over the last decade or so, it becomes even more pronounced for companies to really look at the legal landscape of the enforcement structure, the laws, and what agencies have what powers with regard to enforcement of intellectual property, because slowly we have more and more countries that are giving, whether it's their border enforcement authorities or the prosecutors, the ability to go after criminal and border measures types of actions when it comes to patents. I think I'll stop there. I think it truly is a nation-to-nation kind of situation.
Thank you. Sean.
Thank you, Scott. I think the Chamber started out about 8 years ago thinking about the rise of state capitalism and what the response should be. And in the context of those discussions, we were central to kind of pushing the U.S. government to advance new disciplines in the TPP. And when we sat for the better part of a year and a half, kind of spitballing in a room with a number of lawyers, various scenarios that we saw around the world, the issue of government-sponsored patent pools was not exactly at the fore of our conversations. Right. That being said, we did have concerns related to intellectual property. It is not uncommon that various kinds of policies a government may have in place are designed to force tax transfer, advantage their state-owned enterprises. Certainly the whole idea behind SOEs in many countries is to kind of put the government at the commanding heights of those industries that are strategic. What can be more strategic in today's economy than intellectual property? So while I think when we were developing disciplines that we were looking to advance and push through the U.S. government and into the TPP, we weren't necessarily thinking about government-sponsored patent pools. We were thinking about this larger environment which we see the interface between kind of commanding heights questions, state-owned enterprises, and intellectual property. What do I think the provisions in the TPP come out, and how do they apply to this conversation? I am not a cleared advisor, so I have not seen the text. I've been very, very intimately close to the negotiations over the last several years, and let me make a few observations. One is that I think when the text does come out, you'll see provisions across kind of four core spaces. One is, what does it mean for governments to be financing SOEs? So there'll be a question of provisions related to subsidy. Two, there'll be, what does it mean for government to provide regulatory advantage? So there'll be provisions that speak to that question. The third area which you'll see in the SOE text will be, what does it mean for the SOE itself to be making decisions in the marketplace? And is those decisions free from government influence? And I think the fourth area you'll see in the text is a series of kind of transparency provisions that allow you to kind of attempt to see behind the curtain to determine whether or not the first three kind of core obligations are in fact being followed. So applying that to today's conversation, let me make a few points of where I think the SOE text is helpful and reads on this question, but also where I think the answer is incomplete. And therefore, I would suspect when we read the text, it doesn't completely address the issues presented by government-sponsored patent pools. First of all is the definition. What is an SOE? I think what you'll have is a lot of debate and discussion about what qualifies as an SOE. I expect the definition in the TPP will be something along the lines of an entity that is more than 50% owned by the government. There may be some other language about whether or not there's appointment of board seats and these kinds of things. But if the government has a minority shareholder interest in the patent pool, you're out of the game for whether the SOE obligations would apply. Secondly, if you're not even government owned but government supported, I mean, there are national champions out there that get advantages. Certainly, you have to have ownership, and you have to have ownership above 50%. So I think the first threshold question is, what does the ownership structure look like for these government-sponsored patent pools? And therefore, that'll let you know whether or not the TPP-like obligations read on the matter. Subsidies. Obviously, subsidies is a very contentious issue within the global trading system already. Many would say that the current subsidies framework is broken, doesn't really work well. Others would say, no, it actually works reasonably well. We weren't going to go and create, I think, in the SOE environment, a whole new subsidies code. And so I think what you will see there will borrow heavily from what already exists. out there. It makes sure that the SOEs are subject to this question. I think it puts a little bit of a higher burden on the government to SOE relationship from a subsidy standpoint, but it differentiates what happens in a goods context from a services context. Obviously, there are not provisions on subsidies for services in the global trading system. Here, I think you'll see that there'll be, for the first time ever, some attempts to get into that space, but we'll distinguish between services that are provided domestically and those that are services provided for export. And so it's not clear entirely in these scenarios how much the subsidies language will read sufficiently on this. On the question of regulatory kind of favoritism, I mean, I think this is a big one. You know, you mentioned public procurement, subsidies, local content, and SOEs, but you didn't mention national treatment and non-discriminatory treatment. I mean, I think one of the questions I've heard in this context is, you know, who does the government-sponsored patent pool license to? You know, IP in theory gives you an exclusionary right to choose who you license to and who you don't license to. Now, if the government's owning this, you know, they can pick and choose who they license to, but there's supposed to be kind of a non-discriminatory treatment kind of obligation, a view of national treatment type of view. How does that interface? I think here the SOE obligations and the TPP may be more useful. Similarly, I think there are other provisions that we'll talk about in this space to make sure that if someone is suing an SOE in the country, that the government cannot say that the SOE is immune from litigation because it's operating in the commercial space. This is consistent with the U.S.'s Foreign Sovereign Immunities Act. And so I think there'll be a number of provisions here that potentially, depending on, you know, how the various patent litigation might be framed, you may be able to, we're thinking mostly of the offensive interest of the patent pool trying to assert its patents. You may have the government playing defense in some of these cases as well. So I think in the context of making sure that the regulatory treatment of SOEs is done in a manner that ensures that SOEs are not getting an unfair advantage in the marketplace, I think here you may see the provisions in TPP being more useful. Finally, let me just mention on the issue of the SOEs operations in the market. Here, I think we didn't break as much ground as I think we had hoped at the Chamber in the TPP. There's been this long-standing precedent of talking about SOEs or state enterprises operating in accordance with commercial considerations. What exactly does in accordance with commercial considerations mean in terms of how they make their decisions? And I think this is an area where you start interfacing with kind of a competition more analysis as to whether or not the firm is maximizing profits or not. Whether or not government influence is there is very difficult to see. And I think here you get into a very kind of murky world where, for example, is the SOE making decisions to bring lawsuits because it's in their commercial interest or because the government is directing them to do so? And so I think there's an importance to try to find ways to refine what is encompassed in kind of a company that is state-owned operating in accordance with commercial considerations. And one point politically that I would overlay on that, and then I'll stop, is that when we were meeting with governments in the TPP, particularly those governments that had significant state involvement in their economy, one of the things in which they were most concerned with was whether or not there would be a level playing field. I don't use that term in the context of the SOE debate because what the challenge there is many of these provisions that we are seeking in the context of a trade agreement do provide some degree of disadvantage for the SOE. There is a higher burden placed on them for transparency. There is a responsibility to ensure that a government is not abating their trade commitments. And so you have to be careful because as you put these provisions on, you will hear governments who are using SOE saying, well, this makes our SOE less competitive as a result. This is unfair to our SOE. After all, they're just a commercial actor. They're arm's length. You can't load this thing up because it'll tilt the competitive balance against the SOE. And so as we think about these things in the context of government-sponsored patent pools, I go back to things like, you know, the government, if a patent holder has the right to exclusive use of their patent. If we're going to tilt that balance, what does that mean in a trade agreement? If you're going to go and borrow the term FRAND from the standards patents competition debate, do you require licensing in a non-discriminatory basis on reasonable terms? These kinds of questions. This is not all these patents were developed in a standard-setting context, so you're now expanding that in a way that wouldn't be applied to a private patent holder. So I think what you'll hear in the trade world from those governments that are involved in state commercial activity, they're very much concerned with protecting their ability to see their state firms compete, which gets you into a very dangerous conversation of what is a level playing field.
Thanks. Malcolm.
Well, I'll associate myself with all the comments that they've laid out some of the potential concerns. I will say that it's not my sense right now that this is a burning issue that U.S. government officials are hearing from U.S. companies or IP holders about, but I fully agree it's a potential issue that we need to watch closely. And just to set a baseline, I made some calls to U.S. government officials who are about what does the United States government do in terms of development of their own patent pools, and their U.S. government in their federal research, federally funded research, does fund the R&D, which their goal is to. Most of it is pre-competitive. We have laws that are designed to help transfer that technology out and to get it commercialized. Often it is to raise all boats, so it could be licensed regardless of nationality to develop and commercialize technologies. Occasionally there are pools formed with consortiums. Research is done both jointly with the government and the private sector. Some of that is just U.S. Some of that includes foreign. One example would be, up at NIST, they're developing, lightweight, strong metals for the future of cars, to help promote fuel efficiency, et cetera. The consortium involves U.S. companies, European companies, Japanese companies. I don't know whether it includes, Chinese companies or not. But there will be a patent pool with that. That will be, and the participants go away with patents that their ability to, they have ability to commercialize. But there's nothing in the form of what some other countries are doing in terms of building patent pools intentionally in specific areas of technology for the purposes of monetizing that. That as far as one U.S. official said, well, when we develop this research and these patents, federal agencies or federal labs, we're lucky if we've got someone. We feel fortunate if we've got someone who's willing to commercialize it. In terms of, I'll raise two areas. Is a sovereign patent pool distinctly different as a PAE or a patent assertion entity or a non-practicing entity than a non-sovereign pool? I think a very key point is that they be treated commercially, that they act as commercial actors, and that's where the trade obligations what were just mentioned. The obligations to operate in a commercial manner, be subject to all other IP rules, competition rules, be applied equally. So trade agreements have really a very important role in that regard. And then to the extent they are litigating in say, the U.S. market, the question goes then, if they are treated like any other entity, then the same issues about reaching that right balance on patent reform applies to state-owned enterprises. And there's legislation pending. There is activity by the Supreme Courts. by the Supreme Court, by the Administrative Conference, to try to strike that right balance on potential patent abuse. So it's it's really important that the state-owned enterprises be treated as commercial entities like any other entities, and so that in a country like the United States, where you have independent courts, you have neutral regulators. I've relative confidence if SOEs are treated as commercial entities that potential abusive litigation or anti-competitive conduct can be addressed by our regulators and by our courts. I'm more concerned in markets where you may not have an independent judiciary, or you have regulators who are promoting industrial policy and favoring domestic entities, for there to be opportunity to get issues of abuse addressed. And that is, again, where the trade agreements come into play. I think we can open it up to questions now, and we can.
Yes.
We can.
Let me first ask if panelists have comments, or questions, or remarks about the other panelists. Mark.
Well, I just want to say that the weapons that we have to use in this space are going to be a little different. The reason I didn't mention national treatment is that GATT 3.8 exempts both procurement and subsidy from national treatment. That means on procurement, the only way that we get at the kind of access that we're looking for is if the country has signed the government procurement agreement. On subsidy, we have no national treatment. That's why we're all of a sudden back to SCM 3, SCM 5. That's why specificity is going to carry the day. I am a cleared trade advisor, and I have read TPP, and in fact, my ITAC is the technical barriers to trade one. We do all the regulatory heavy lifting. Let me just say that I worry a lot about the way in which this is going to get linked to TBT. I worry a lot about the potential for us to not even have the language at times to grapple with something called a state patent, a sovereign patent pool. TBT is becoming so esoteric, and the regulatory demands that we are making of the European Union in particular are so far from anything that has been done previously that I worry about the theme that is popping up in all of our little presentations, namely, what happens when I regulate myself? And when I think about how Europe has responded to some of our TBT plus demands, that is a big concern, because even among rich countries, forget about the heterogeneity of TPP, even among the rich countries, this is proving to be a real test. So as you add IP in, and if you want to include a service with that as well, then we're really into some murky terrain, especially Mode 3, Mode 4. We are not getting a lot of concessions, Mode 3, Mode 4. The introduction of IP is not going to help. If anything, it's going to hurt.
Yes, good point. Let me ask the panel just a toss-up question quickly. One of the common themes in your remarks has to do with sort of the character of the way these enterprises operate. And you can, I think you all speculated one way or another that there could be legitimate applications here, but that somehow it is in the operating dynamics of the firms themselves, which is a hard thing to regulate. It's a hard thing to specify in advance in trade agreements. And so, I would go back to an example where there was about maybe 7 or 8 years ago a moral panic about sovereign wealth funds. Mostly in Washington. It was a self-contained, flamed out pretty quickly. The reason it flamed out as an issue is because it was widely recognized that most sovereign wealth funds were basically portfolio investors. That they were there to make some money, okay? And then secondarily, it turned out at that point in the United States, we needed the money. So, one way or another, it was a self-limiting problem. This one, I don't see the same self-limiting characteristics because it's very difficult to constrain intent. So, just any observations the panel might have on that.
Well, I guess I would agree. I mean, there is no self-limiting intent to be able to see how something will be used, and certainly it'll change over time. I mean, and that's why the transparency provisions of the TPP are at least aimed at trying to get a view as to what is the intent and how the interface is between the government and the enterprise. But certainly as the U.S. Chamber, we don't believe in much government involvement in the economy. So,
Right.
you know, domestically, we would not be in favor of seeing the U.S. stand up a series of kind of state-owned enterprises to do commercial space. I mean, I think we still rail against the federal prison programs and what we do in terms of commercial activity there. But obviously, internationally, I think we've come to the understanding that every government will organize its economy differently, and that we're not going to be, through a trade agreement, able to force economies to organize themselves in the way we would want to see fit. But we do think that there needs to be some understanding between how a government chooses to organize its economy and what the trade obligations are, and therefore that's why we do advance these SOE questions. But I do think it is different than the sovereign wealth fund question. This is one reason why, as part of our TPP SOE work, we weren't trying to attack sovereign wealth funds as portfolio investors is not an issue that, that causes concern.
Okay, thanks.
Scott, I'd
Yes.
just say that, you know, some of these places you have actors in the enforcement system who are already predisposed to protecting domestic companies when
Yes.
it comes to IP. So now when you add this element, I think the possibility that, well, if somebody is predisposed to helping domestic company, when you have a potential government role involved coming and asking for enforcement, the likelihood is, again, they're going to be predisposed to take action without looking independently at whether or not that action is really warranted.
Fair point, yes. Thank you. We have a very expert audience today, selective but expert, and so I want to welcome you to ask your questions. Before we get started, there's just three simple points to follow. First, once you're recognized, wait for the microphone. Because of our online audience and the recording features, your question really won't be heard by the audience unless you wait for the microphone. Second, identify yourself and your organization. And third, please make sure your question is in the form of a question. No statements, please. So with that, are there questions? Yes, sir.
Ira Tynowitz from MLEX News Service. Is there a difference between an enterprise, a state-owned enterprise doing patents, prohibiting patents to non-country members, and allowing it, in other words, permitting licensing, but putting in some sort of provision that gives special access to people who to work in this country? So, for instance, to give a better example, if the state of Illinois were to go ahead and offer a program, and we will license, and Illinois were to say, we're going to license this to anybody who wants, to any country, et cetera, but if you produce in the state, we're going to give you a discount on the cost of the patents. Is that different from just banning anybody outside the country from using the patents?
Well, from a TPP SOE standpoint, I don't think we go sub-federal. So you're talking about right there the issue being off the table from the SOE trade rules. I would also say that you're talking about the state of Illinois, which might arguably fall more into kind of the government procurement versus the state of Illinois setting up a state-owned enterprise that does this work, which would then not be outside of a procurement context in terms of the purchases and sales. But certainly, if it was a federal government patent pool that was established vis-a-vis a state-owned enterprise where you would own 51% of the company under the TPP obligations, as I understand them, the discriminatory treatment by the SOE in terms of how and who it licensed to would be in some way, shape, or form disciplined by the TPP. You'd have to know the exact fact sets associated with how it's differentiating in the market and whether that would qualify as kind of a discriminatory kind of act. But yes, I think there would be the potential, if you change your fact pattern slightly, under kind of what is envisioned, as I understand it, in the TPP, for potentially TPP obligations to read on that. Even if you license to everybody, but you may charge different rates. So, if you license to domestic firms at a tenth of what you license to foreign firms. That would be, you're still licensing to everybody, but you are making a differentiation there. Yes, even in a context where you could be licensing to everyone, you still be running up against obligations in the TPP.
But here's the hypothetical. Imagine that the government of India, under TRIPS 31, triggers a compulsory license on a patent that the U.S. Sovereign Patent Fund owns. And the government of India does so under the India Patents Act, anywhere between sections 84 and 92, invoking the work the patent clause on the American idea. That would be fun. That would be fun. Because I think that is part of the asymmetrical licensing issue.
Yeah.
Namely, the compulsory licensing, which the Chamber has done such a great job bringing to the awareness of the American people. The issue of the licensing is going to get worse before it gets better. And it's not just on drugs. The compulsory licensing in solar, the compulsory licensing in semiconductors. My hypothetical may ring true sooner than later were that to be the situation. And that presents really interesting offense-defense considerations. So as a hypothetical, that would be kind of the state of the art.
Very interesting. Also, I would note that the notion of a state-owned, or a U.S. state owning patents is not far-fetched at all. If you look, one of the largest non-practicing entities in the United States is the Wisconsin Alumni Research Foundation, which is part of the University of Wisconsin, which is part of the Wisconsin state government. So it does happen, and the questions are valued. So, other comments, questions? Hearing none, I do want to make sure everybody has a chance. This is an area that is, we understood we were taking somewhat of a risk with this program while the rest of the city is talking about TPP and the congressional fight that's upcoming to get into an issue which is very specific to a certain class of products, a certain type of innovation, and is relatively new. But it's also, it was our goal to present this and kick off the discussion. Yes, question in the back.
Francine Friedman with Aiken Gump. I wanted to ask if you all could elaborate a little bit more on the kinds of things a government can do when they are both the regulator and potentially the licensor. So the ones who can determine whether you can get the license, how much to charge for the license, but also potentially keep your product out or do other things to sort of get a leg up or have better negotiating power.
I'll comment on that. TBT, the Techno Barriers to Trade Agreement, was mentioned. In the technology industry, obviously, standardization standards are very important. Where you have a government that has the ability to determine the participation in a standard-setting body, the IP rules of a standard-setting body, and then ultimately, in some cases, mandate the standard for application within their, and you've got governments building patent pools so that they are dominant in the space in which the standard is going to be set by the government. You've got, you've got an issue there of industrial policy. And it's an area of deep concern. I think U.S. industry and the U.S. government has pressed hard, through, back 10 years ago when I was, in the private sector representing, big tech companies, for voluntary, industry-led, international, open participation in standard setting, and that these standards that are set respect intellectual property. That principle is generally contained in the WTO-TBT agreement. I haven't seen what's in, but there are exceptions. There are exceptions for governments to mandate standards. There are exceptions for national security, which, as you know, in many countries China just passed its own draft cybersecurity law, national security law. That is being used to give the government broader scope to set standards and to set the terms under which technology is purchased by the government or used even more broadly, including in non-government areas such as banking, commercial technology used in banking, the banking sector. There is in the standard space, in technology at least, a great potential for the type of industrial policy that we would be concerned about coming out of state-sponsored patent pool.
Tim, you are sort of at the coalface on this issue.
I was just going to add, when it comes to the enforcement side, I mean, if you're stepping into the shoes of the patent owner to exercise rights and go after potential infringers. In the area of patents, I think when we're talking about other types of enforcement other than civil litigation, if you think about who is involved at the forefront of the enforcement, whether it's the Customs Administration, prosecutors, police, when it comes to criminal and border enforcement, I think here you have the possibility of the sovereign having an overwhelming amount of influence on those people, simply because usually these folks who are doing enforcement aren't dealing with patents and the technical elements of patents. And so the influence that the sovereign has, the potential influence the sovereign has on those people actually involved in the enforcement is, I believe, so much greater. It's one thing to say where, for example, whether it's the US, Japan, Europe, where 90+% probably of the border enforcement seizures are probably trademark based. Okay, and then you look and say, well, all of a sudden in the EU or Japan and China, you have the potential of border enforcement at the border. You're dealing with people, customs, they really don't get involved in patents hardly ever. And therefore, the sovereign has a greater possibility of influence as to how that agency, which is part of the government,
right, is
going to act. And I would say similarly, that's probably going to be the case in the event that a country has the possibility of criminal liability for patent infringement. But because again, how many prosecutors or police who do the investigation and gather evidence have any background dealing with patents? And
there aren't many customs agents who are patent
certainly
attorneys.
not. And so, and when you look at some of the countries that have gone forward and actually extended their patent enforcement authority to the border and into the criminal area, it is rather interesting to me which countries have decided to do that. And then when we look at some of this discussion about sovereign patent funds and pools, it's also interesting to see where those are. And so I think that the possibilities for undue government influence is very great in some of these countries.
Yes, ma'am. Follow-up question.
Yeah. Just to follow up, given the fact that they could influence the regulators and keep your products out, for example, does that also in your mind give them the ability to potentially command a higher license fee or impact markets in ways that maybe we wouldn't be so happy with?
I certainly think that's a possibility given the discussions we never know about that could go on in order for, let's say, customs to release a shipment. Or even when prosecutors are talking to somebody about their criminal liability and what may happen. I mean, there are a lot of things we don't know. I mean, even in the United States years ago when I worked at Customs, you had importers getting in contact with the trademark copyright owner in order to get shipments released. And clearly, in that case, we did not know about the details of those discussions that go on, but it happened occasionally. And certainly in this area, the possibility may be greater for those discussions to occur.
No, I think similarly, if you were to try to bring, if you were a licensee, approached by a state patent pool, and say it's in a standard, even if there's a fair, reasonable, non-discriminatory application for a royalty payment, what's your recourse if you disagree with what a fair royalty is? You go to, you could go to a court in that jurisdiction if you're being approached in that jurisdiction, you could challenge the patent quality, or you could assert some abusive IP. Will the court give you a fair hearing when they're up against the state patent pool? Likewise, if you were to go to the antitrust regulator and assert IP abuse or misuse, are you going to get a neutral hearing? Will the government prosecute its own sovereign patent pool?
And what happens under the bilateral investment treaties, where a company sues a government for tantamount to expropriation by virtue of threatening over intellectual property? And not even threatening explicitly, but threatening by virtue of doing something within the patent pool that has the effect of undermining the value of the asset on the ground. So lots of permutations.
Also, not far-fetched at all, given that there is a current dispute between a U.S. company and the government of Canada over its patent law, and its application of patent law. So, in any case, welcome to the world of trade policy, where no old problem ever gets fixed and new problems emerge all the time. So, it's the wonder of working in this space. It's why I've stuck with it all these years. But in any case, thank you for joining us today. Hope this was beneficial to you, and please join me in thanking our expert panel.